back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3 today. We got a lot on the plate. Hey, for our chatters, thanks very much for all those great compliments. It's great to be with you. I'll be checking in to see what your questions are in these two fascinating cases that we're covering here on the Law and Crime Network. Welcome back. Listen, let me bring my great guests on. You could not get a better team than this. Judge Ashley Willcott, a juvenile justice judge and also a host here at the Law and Crime Network, and Gene Rossi, my man, even though he kind of strayed a little bit this week and went with some other hosts. It's okay, Gene, you are forgiven. But he's a great trial lawyer, 30 years with the DOJ, both extremely capable trial people. Guys, let's get right to it. Question one for you. Ashley, I'll start with you. 6 years old, there's contact with the police department. My question, again, my prosecutorial nerve is getting uncomfortable here with this case based on everything that's going on in her representing herself. Is there an argument to be made in the penalty phase that she was an incapable mother and that law enforcement and the authorities should have stepped in earlier and this wouldn't have happened as a potential mitigating factor weighing against the death penalty? Thoughts?
No, I don't think it should be a mitigating factor. Is it true that there was a system fail, that a lot of different people touched this child and should have been able to prevent this death from happening? Yes. I do not think that's a mitigating factor because that does not excuse or make any better the fact if this parent is convicted of abusing, torturing, and killing her own stepchild.
Okay. Gene, we've talked about this a couple times before. She's representing herself, chose not to give an opening statement, not cross-examine any witnesses. The reason I'm worried as a prosecutor is, one, does this affect the jury who says, you know what, even though she chose to do it, we really don't know her side of the story? Or two, is this maybe an effective strategy, as I indicated before, that you don't want to really go after the guilt phase of the case when it's a lock for the state, but you want to put all your eggs in the basket of the penalty phase where you're trying to get life without parole as opposed to death? Could this be what's in her mind?
No. I think her strategy is this. She's going to be so incompetent that when the appellate court sees the lack of effort in defending herself in the face of the death penalty, I don't think an appellate court's going to affirm this conviction. Now, I would want to add, she didn't do an opening statement. That doesn't mean she eventually will not, because she can reserve it for her case in chief if she puts something on, but not to cross-examine people. It appears these could be important witnesses, not to cross-examine them. That's a recipe for disaster, but maybe she wants the appellate court to see the disaster.
Gene, I'm going to come to you first. I find this very compelling testimony for the prosecution because what the jury is hearing is that, if I got this right, and correct me if I'm wrong, the victim in this case, the little 10-year-old girl, is not her biological child, and she was abused, presumably for a number of years. But the other two children that were her biological children were well managed and cared for, which shows me that as a prosecutor, I would be railing, is that she made a specific choice against a specific child. She knew exactly what she was doing. What do you think?
Well, the thing about this testimony is twofold. One, you got motive. The child, Emani, is not the blood of the defendant. And for whatever reason, the defendant didn't have that affection for Emani that she obviously had for her own blood. And number two, when you go to the death penalty phase, one of the aggravating factors will be, I'm sure, given to the jury, what's the level of premeditation that was shown in this trial that resulted in a death? And according to Robin Moss, the grandmother, there was a lot of premeditation. She wouldn't allow the grandmother to come to the home. She was isolating other members of the family, including the grandmother. That all goes to premeditation and a calculated decision to torture and kill Emani.
Gene Rossi, you know what I'm about to say. I have mad respect for the guy who's in charge, or the girls in charge of the office, that gets up there and puts it on the line in a serious case like that, because we should have more prosecutors' offices that are run by people who are real trial lawyers like this guy obviously is. How do you think about how he's doing in there?
I love this guy. Old school. No PowerPoint. No notes. No fancy charts.
Yeah.
Just oratory.
Yeah, Gene, we talk about that so much. And for our lawyers, young lawyers that watch us, or law students, it's so powerful when you're not distracting the jury with all of this extraneous, hoopla. He is the center of attention, delivering a great job. Let's listen to some more. Okay, Gene, obviously doing an effective job. And when he's going through the details of the cover-up, it's not just only insanely insensitive, if that's even the word that you'd use for what the defendant is alleged to have done, and callous, but all these actions show consciousness of guilt. What do you think?
Oh, yes. And more important, it shows the complete and total disregard for someone who's a member of your family, even though the person does not have your blood. And I got to tell you, God help her in the death penalty phase, because I don't see any mitigating factors. Absolutely not.
Right, and but do you think for her, given the way the prosecutor's laying this case out and the evidence that they have, that it could be a smart move not to insult the jury by trying to cross-examine your way out of the guilt phase and save your fire for the penalty phase if you were the defendant? I'm just saying, if you're trying to save your life.
You know what, Bob? When we just took the break, I was actually thinking about that exact thing. If she had attorneys, they probably wouldn't cross-examine many of the witnesses. So maybe she's either thinking of that herself, or she's taking some advice from the standby counsel. That is a strategy that in the guilt phase, you don't put up a fight and you save it all for the penalty. That could be possible.
And Gene, there's an inherently different feel if a lawyer is attacking your mother, is attacking the government's witnesses, as opposed to you personally as you're trying to save yourself doing it, which could come off as being rude and arrogant. If your lawyer does it, it's almost expected. So it's hard to get up there and start cross-examining witnesses because it just makes you more unlikable.
Right. There was a famous case in Long Island, Colin Ferguson. He went on a train and he took a machine gun basically and killed several people. He represented himself and he was cross-examining some of the victims who were shot but did not die. And wow, it did not go well. I think that was in the 1990s.
Yeah, I mean, I can definitely see if a lawyer were doing it, it would be expected. It's a little bit of distance there, and when you're doing it and you're the ones alleged to have harmed the victims that you're getting in their face in a courtroom, it can really spin off in bad ways. Gene Rossi, you're always giving us a great commentary. Thank you. One of the witnesses, as we were just talking about, is the grandmother who testified. That's Robin Moss. So just think about it, folks. When you guys are listening to this examination, should she have gotten up there and cross-examined, or just let it lie and put all her eggs in the penalty basket? I mean, the evidence is piling up here. I mean, not a good look for the defendant, where the grandmother is getting up and saying that to cut the girl's hair, and when asked why, is you act ugly, you look ugly. Not good.
I'm wondering if this defendant has an argument that she had a diminished capacity, because this is just cold and calculated.
Yeah. Gene, it's funny you should say that. I'm going to ask the producers when we're offline. I don't know the answer to this, but you bring up a good point here about if you're going to go penalty phase only, put all the eggs in the basket, the typical, standard, prototypical thing you do as a defense lawyer is present expert testimony to try to give some explanation and context to the jurors as to why a person did such a heinous thing, but I'm not sure whether or not we're going to see that in this case, and that all presupposes she's got the capability of knowing how to even examine those witnesses, should she even have them.
Right. You know what, Bob? You know what could happen in the penalty phase is the judge may take control and say, listen, defendant, I'll allow you to represent yourself to a limited degree, but I have discretion to have standby counsel over your objection, because your life is on the line, to put on some type of mitigating case. And I bet you the judge does that.
Let me ask you, Gene, any hope for the defendant in the penalty phase should it go like this? I haven't fought this. I didn't even ask any questions. I didn't want to waste anybody's time. She's giving an allocution to the jury, which you're allowed to do in a penalty case. I'm terribly sorry for what I did. It was horrible. I'm a bad person, and I deserve to die. But please don't kill me for one reason. my other children who still need their mother. Could be an argument that catches one person.
You know what, Bob? If she did it and did it in 10 minutes, I think you're right. She would have either a hung jury or possibly life imprisonment.
All righty, guys. Gene Rossi, stick with us. We're going to clean up some house here, do a little business, get in that chat room, find out some more answers to those expert questions for you. Law and Crime Network. We're going to break. We'll be right back. Okay, so Gene Rossi, that's the 4th grade teacher. After that year, the little Emani was taken out of the school, homeschooled. But listen to the power of this testimony. I know you know this for sure. Talking about her, that she wanted to be friendly with bullies, that she was sweet, precious, great adjectives to describe this little girl, that when there was this one person that was mean to her, look at her right there on the camera, she kept trying to be nice, and that she would, face would light up when she would speak, you know, about other children and her siblings. So there, in addition to the fact that that's great impact testimony emotionally, to me it's also showing she wasn't a problem child that needed to be physically corrected.
Yes, that would be the major proffer, because this is really testimony that should be in the penalty phase versus the guilt phase. But that would be the proffer that the prosecutors probably are putting this witness forth. It just shows that this Emani had incredible potential, and her life was just snuffed out.
All right, Gene, so we got some authentication going on here with the officer. The state's case is moving with blinding speed. Vincent Hill indicated he thinks it may be over with by Friday, at least the guilt phase. Probably quickest death penalty case I've seen. How about you?
I'm hearing two things. I think I heard you. I think, Bob, this case could end Friday or Monday.
I'm waiting with bated breath, Gene, on what she does in the penalty phase of this. I mean, we can only guess at this point, and we've batted it around. It could be a rather effective strategy. And Gene, to the point of the other lawyers that are there in the courtroom with her, although they're not participating, she did on 2 occasions, go back to them during jury selection and seemed to be nodding when they were speaking to her. And she had kind of like the cadence down with the photographs in terms of agreeing to allow them to be admitted. So maybe she is listening to them.
Yes, I get the feeling that during breaks or after court is out of session, she is getting sort of a law school class course on how to try a case in real time, because she does appear to understand sort of the cadence, why exhibits are shown to her. I got to tell you this, Bob, I'm a firm believer that the jury is always looking at that defendant. Always, always, always. And the optics of her sitting by herself with an empty chair behind her just shows a level of isolation that I don't think is helping her.
Yeah, and to Judge Ashley Willcott's statement and her assessment was that, and it may have been yours as well, Gene, that she doesn't seem to be too impacted or moved by some of this compelling testimony. Certainly the jury will be looking at that, and that will not be in her favor. Gene, our time together is coming to a close. I'm going to leave it to you for the next 60 or so seconds. You're a trial trainer of prosecutors. Everybody can be a little bit different. Everyone has different styles and different cadences and different personalities. But this guy hits high notes. There's something that imbues credibility. I love his style.
There are 2 things that strike me about him, among many, is he uses the pause. Silence can be deafening. And what he does is he makes a statement or statements, and then he pauses. And he lets that jury ponder the 3 or 4 sentences that came out of his mouth. The second thing he does is he uses simple language that appeals to the common sense of the jury, because in any trial, Bob, the common sense of the jury is the soul of that entity.
Gene, you know that I often say that that's it. Common sense, common sense, common sense. It doesn't need to be sophisticated. It doesn't need to be pretty. It needs to be real and to the gut.
Bob.
Guys, this is the Law and Crime Network. If you want to find Gene Rossi, go to Rossi4VA. That's his Twitter handle. And mine at RBianchiESQ. We love to have you aboard. Keep watching. The great Linda Kenny Bod is next to pick up the coverage. I'll see you next week.